In focus tonight, a preliminary hearing for all 6 officers charged in the Freddie Gray case is a little more than a week away. Now, in that hearing, we could hear more evidence in the case against them, if it gets that far. Many say City State's Attorney Marilyn Mosby will go to a closed grand jury for the indictments. In focus, investigator Brian Kubler is here now to explain what that means.
Kelly, much of the evidence will not immediately become public record, but some experts say some of the charges have to do with refusing medical attention to Freddie Gray, disregard for his apparent injuries, and negligence for not securing him in that police wagon. But the mandatory use of seatbelts for prisoner transport was a policy order that was not only just recent, it just barely existed prior to that Sunday morning in question.
We have probable cause to file criminal charges.
Baltimore City State's Attorney Marilyn Mosby has had her critics since she announced charges on all 6 officers involved in the death of Freddie Gray. Paige Kreuter, a former assistant state's attorney in Baltimore, has been vocal in what she calls Mosby's rush to charge.
That she went too fast, that doing an investigation like this in only 2 weeks could not have been as thorough as it needed to be to have confidence that these were the proper charges.
An example may be the assumption that the Baltimore 6 even knew of the policy to seatbelt Freddie Gray or any other prisoner inside the police wagon.
And at no point was he secured by a seatbelt while in the wagon, contrary to a BPD general order.
During her news conference, Mosby mentioned the Baltimore Police Department's general order to seatbelt prisoners 6 times. The last mention indicating various officers had either ignored or neglected the BPD order several times before the wagon's last stop that morning.
Officer Goodson then proceeded to the Western District Police Station, where, contrary to the BPD general order, he again failed to restrain Mr. Gray in the wagon for at least the 5th time.
But using seatbelts for prisoners was not only a recently adopted policy, it had barely existed. The procedure to buckle in a prisoner is part of Policy 1114. On page 2, it reads the detainee is secured with the provided seatbelt or restraining device, and that all passengers, regardless of age or seat location, shall be restrained. While previous reports say this new policy was published April 3rd of 2015, ABC2 has learned it wasn't approved and emailed out to officers until almost a week later. In Focus has obtained the department-wide email confirming as much with the timestamp 6:01 p.m. on April 9th, just 2 full days before Freddie Gray would be arrested in the Western. But along with Policy 1114, which was 15 pages itself, the email contained 5 other new rules with PDF attachments, some double that length.
How am I supposed to know for sure that my client knows that these orders have been changed and that this is the new rule going forward?
Matt Wyman is a defense attorney in Towson and familiar with the case against the officers. He says if he were representing one of the Baltimore 6 charged in relation to failing to seatbelt Freddie Gray, whether or not his client was made aware of the policy change would be the first thing he would look at.
When the order's only that fresh, I mean, we don't know for sure if the officers that were involved had worked on previous days, if when this order went into effect, if they were informed of it, if they had been sent an email. You know, we don't know if for sure if they'd read that email.
Or even told in roll call or other means. There are overlapping shifts, days off, and overtime relief. Plenty of cracks for a lengthy new rule to slip through in just 2 short days, Wyman says.
If I were representing one of them, it would be a priority to find out, did they know that this procedure had changed? How were they informed of that? Were they trained on what the new procedure is going to be going forward? Or was it just an email that maybe wasn't read?
Now, before this policy was rewritten and issued last month, using a seatbelt for prisoner transport was evaluated by the officer on a case-by-case basis and was not mandatory. Policy 1114 also includes language on medical aid. The new general order says officers should ensure medical treatment for a detainee when necessary or requested. Now, once a Baltimore Police general order is issued, it is considered immediately effective. Police say notifying officers of new rules is the responsibility of commanders. The notification process, some attorneys say, could become part of the defense to see if these accused officers knew of the change and when.